No governmental agency in Georgia has the authority to intervene in a dispute between a landlord and tenant that cannot be resolved by the parties through the court system. So, in order to involve any dispute between a landlord and a tenant, you have to go to court. You can't call the police. You have to resolve the issue through the court system. The basis for judicial decisions that decide landlord-tenant disputes come from two sources: the Legislative Code of the Landlord-Tenant Act and prior judicial rulings that clarified this statutory law. So laws are usually based on previous caseloads or previous case history. And usually in judicial decisions, look at prior case history, and that helps them to settle future disputes. Enforceable leases. Enforceable leases. Leases for more than a year must be in writing to be legally enforced in Georgia. More than a year must be in writing. Verbal leases for 1 year or less are legally enforced. Any legal dispute regarding the terms of a verbal lease will be decided by the courts because there is no written evidence of what the parties agreed to. So verbal, 1 year or less, is enforceable. Written leases of more than a year are legally enforceable as well. If no time period is specified in a written or verbal lease, the lease is a tenancy at will and can be terminated at any time by either party. A tenancy at will can be terminated at any time by either party if there is no specified beginning and end period. To terminate this tenancy at will, the law requires 60-day notice from the landlord or 30-day notice from the tenant. Notice has to be given. Even if it's a tenancy at will, notice must be given. Security deposits are not required by law. Quiet as it's kept. Security deposits are not required by law. But if provided to landlord or landlord's representatives, the funds must be deposited in a trust escrow account. Now, if the community or the home that you're moving into requires a security deposit, that's a different story. The landlord is not bound by a statutory limit on the amount of a security deposit charged to a tenant. The landlord has 30 days from the end of the lease to return the security deposit to the tenant. So a landlord, there's no standard amount for a security deposit, okay? The landlord can say your security deposit is anywhere from 0 to 2 times the rent to 3 times the rent to, they determine what the security deposit is. There is no statutory limit on there. But once your lease is up, once that start and end date, the terms of the lease has come and gone, the landlord has 30 days from the end of that lease to return your security deposit. The landlord may deduct from the returning deposit unpaid rent, utilities, or damages caused by the tenant, normal wear and tear accepted. So normal wear and tear is an exception, okay? They can't take anything from your security deposit from normal wear and tear. But if they walk in the unit and they see holes in the wall, floors, carpet torn up, or oil spills or paint spills on the carpet, or cabinet doors falling off or something, that's damages. That's different from normal wear and tear. Normal wear and tear would be foot tracks in a carpet, or rings around the tub, or something, reasonable rings around the tub, something like that, rusting of a light fixture, or something to that degree. Landlord may be incurring a financial penalty for failing to return security deposits on time, which may result in landlord paying tenant 3 times that amount plus any reasonable attorney's fees. Usually this requires some sort of court intervention. If the landlord has not returned your deposit and you have tried your best to get your deposit from them, if you take them to court, then the court can order them to pay 3 times the amount that they owe you, plus attorney fees. Licensee as a principal. An affiliated licensee who intends to participate in any real estate activity as a buyer, seller, landlord, or tenant must first notify the affiliate broker in writing as to this action. Remember, I said before, anything you do, run it by your broker in writing, okay? You can talk to them about it, but then put it in writing. You always want to take the necessary steps to protect your license. When selling or leasing a property owned by the licensee or offering to buy or lease a property listed by the affiliate's employing broker, a licensee must clearly disclose any such position as a principal in the transaction to the other party, as well as making such disclosures in a written contractual agreement. If you own any interest percent in a property, you have to disclose it. You have to disclose it, either on the listing, but also on the contract. You have to disclose it. All ads run by a listing acting as a transactional principal must, absent written permission of the affiliate's broker, must be run in the name of the brokerage firm. Remember, the brokerage information must be equal to your information. If a licensee with the purpose of acquiring a brokerage agreement with a seller, buyer, landlord, or tenant promises to buy a property from the principal, such a promise must be made in writing prior to any such binding agreement. So you see these, there's some broke agents out there who markets themselves, if I don't sell your home, I will buy it. Needs to be in writing, okay? It needs to be in writing. When a broker lists a property and as part of the brokerage contract, the broker or broker's sales affiliate offers to purchase seller's property if it is not sold before an identified date. The licensee must first enter into a written agreement with the seller to purchase the property. Again, I refer to those agents that says things like, if I can't sell your home, I will buy it. If it is not sold, if they give a date, if I don't sell your home in 90 days, I will buy it. Okay? If they don't sell it in 90 days, then they must enter into a written agreement with the seller that they will be purchasing the property.